Is Mr. Wright there?
Hello, Your Honor.
Are you Xavier Wright?
Oh, little beard. Yes, sir. I'm sorry how I look. Let me get myself together.
That's all right. I don't look my best either sometimes. Mr. Wright,
No, you do. I see that beard on you. That's mustache.
Mr. Wright, I'm Harris Blanchett. I'm the justice of the peace. You
Okay.
are charged with the offense of possession of marijuana, a Class A misdemeanor. You had an amount that was less than or equal to 4 ounces, but greater than 2 ounces. Do you understand the charge?
No, well, can I say that it was less than 2 ounces?
I can say that this is what you're charged with. I don't.
Okay.
I'm just here to tell you what you're charged with. I'm
Okay.
not asking if you did it or not.
Okay. Okay. Thank you.
All right. Well, you have the right to hire an attorney to represent you. You have the right to have the attorney with you while you're being questioned by peace officers or attorneys that represent the state. You have a right to remain silent. You're not required to make a statement, but any statement you make can be used in court against you. And you have the right to stop making any statement or interview at any time. Do you understand those rights?
Yes, Your Honor.
All right. And do you need a court-appointed attorney, or you're going to get your own?
I want to represent myself, if that's possible.
Yes, sir. Are you a citizen of the United States?
At the moment, yes, Your Honor.
At the moment, you think you might lose that citizenship?
Well, I was actually headed down to the United Nations to get my foreign citizenship.
Why, you are a citizen then, right?
Correct. At the moment, yes. That's why I stated.
Are you currently out on bond for any other charges anywhere else?
No, Your Honor.
All right, then your bond has been set at $5,000.
Oh, goodness.
You have any questions I can help you with today?
So I was traveling through the states. So I was traveling through you all. As far as a bail bondsman, if I did do a bail bondsman to pay that, how would I go about it with court? Because I'm not.
You'll just call a bail bondsman, have him post your bond, and you'll get out. Then when you come to court, when you get your court comes up, the bondsman will call and let you know when and where your court is, and then your obligation to show up.
Can I do it all over Zoom since I don't live here?
I do not know if you can or not. You can ask the court of that. I'm not going to be the judge of that court.
Okay. I'm sorry. Can you say that again, sir?
Any other questions?
The last part. Yes. How would I get in contact with a bail bondsman?
The jail staff has the phone numbers for the local bondsmen that are across the street.
Okay, and it's 10%, correct?
You can. I don't know what they charge. I've never had to make a bond. So, but yeah, you can call and talk to them and ask them what they charge and see what they do.
Okay. Thank you again, Your Honor.
Thank you.
Oh, that was just rich. It was rich with so much goodness. I know it was short, but he asked for the bailiff bonds. He says he's heading down to the UN to switch up his immigration status or something. I don't know. It's not even possible, but okay. The UN doesn't do that. In fact, I'll go farther than that. The UN doesn't do anything at all. It does nothing of any value whatsoever. It's entirely pointless. It was a good idea, but it doesn't do anything. And then him telling me he has a nice mustache, the whole thing. It was thick.
143 all the way, please. 143 all the way.
Case number 25S01004SM, State of Michigan versus Destiny Hassel.
Good morning. Good afternoon.
I haven't seen this, but I hear we have fun with Corpus Electi.
Almost, Your Honor. Courtney Rose on behalf of the people.
Good afternoon, Your Honor. May peace and solemn with Allison Palmer. Peace and devotion to this on behalf of the second.
Destiny Hassel.
Okay, we're here for trial on one count of domestic violence.
This is all Zach's fault. Thank you very much. Law Nerds Unite. That it's good to have material on Thanksgiving, because let's face it, Thanksgiving's a boring holiday. It's all right and everything, but it's boring.
Yeah, especially, I'm moving for dismissal of this matter. The people do not have a witness,
Okay.
in this matter. And it's my understanding that, and Judge, just bear with me. I mean, I've not ever seen this in 26 years of practice where the prosecutor wants to use a statement by my client as their sole case speak. First of all, to do so would violate the Confrontation Clause of the Fifth Amendment. There is no witness here for me to cross-examine with any allegations where my client can properly extrapolate information to be able to mount a defense against herself. Secondly, it is my understanding that the prosecution, in using this video recording, well, and that's my understanding. I mean, that just violates the Fifth Amendment right to not be a witness against yourself. I've never seen where you use a statement. That's all you have is this statement supposedly on the scene where someone is allegedly admitting, supposed to be an admission, to use that as the prosecution. That would mean that my client would have to take a stand and defend herself against herself. So because she can't be compelled to be a witness against herself for herself, then the prosecution cannot use her to be a witness against herself. If we had a witness here, a complainant who is saying, yes, this is what my client did, and then they use the statement, the alleged statement to, and they use that in furtherance of the case, that's different. However,
This is odd. I haven't seen this, and this is not what I do. Okay, but this strikes me as an odd argument. The Fifth Amendment means you don't have to testify against yourself in court. But if you make an admission, say you say stupid stuff and it's on video surveillance, and let's say you're stealing from a store and you say, I'm stealing this merchandise from the store as you walk out and it's on video surveillance. That's it. That's the evidence. That doesn't violate the Fifth Amendment. You're stupid. You weren't sworn to testify. You're just stupid. And they have a video of you committing the act and saying it.
that's not what we have here. I believe that this prosecutor is compelled to dismiss the case because to go forward, I mean, first of all, there's no one to swear in. I don't know. I guess he's going to swear the officer in and say that he
I mean, I like her pluck, but I think she's wrong so far. I don't know. We'll see.
or she was there at the time, and this is what my client said. But it doesn't matter, Judge. If we started using statements or admissions as sole prosecution against defendants, then what we're doing is setting the whole country up for wrongful prosecution. And so that's all.
If Andrew gets up, we'll all get up. It'll be anarchy. No. I get it. You're trying to make a reach with the Fifth Amendment. I think you're wrong. And then you throw a good slippery slope argument in there to add on to it. But no, that's evidence. There's a confession, that's evidence. You can't get the confession in through that person as a witness if they plead the Fifth Amendment. But you could say, call the person who heard the admission, and boom, there you have it.
We have here.
Well, let me ask you a question. Let's take it out of your client's case.
Thank you.
So you're saying they have nothing else. There's no other witness. There's no injury. There's no nothing that anybody could see.
No,
It's just her saying she did something.
allegedly.
Okay. So I would think, I don't know about anything else you just said. It would seem like that could violate the corpus delicti rule.
It does.
Oh, sweet.
Because you have to have the basis of the crime first, something on evidence before you can use the person's statement. That would be what I would think that maybe could happen. But, you know, and
Yeah, that's what she thinks, unless the defendant's a honky. Then she'd see it differently.
in many instances, people get convicted on their own statements, period. There is something else there that may indicate that a crime may have been committed. But oftentimes, you know, we take it out of your client's scenario. People say things all the time and they get stuck with what they said, and there's no other, you know, witness there.
Well, I've never been a judge. I've never seen it in 26 years, but if you don't have a complainant, you don't have a witness, with respect to,
I've seen it here. Let me tell you what I've seen. I've seen what they call, quote, alternate proofs, where they don't have the complaining witness, but they have something else. Somebody else may have seen something and can make out the elements of the crime. But you still got to make out the elements of the crime. And with the defendant's statement, you'd have to have the elements of the crime separate from her own statement. But I've seen it used plenty of times when they don't have the state prosecutor, not the city.
it is my understanding that the police obviously came allegedly after the alleged fact.
Mm-hmm.
So they would not be an eyewitness where they could testify to anything that was a direct so on the complainant who we don't have.
Okay, well let's I might come back to you. Let's hear what your response is.
Thank you, Your Honor. Sister counsel is aware I have two witnesses present because she came into the prosecutor's office to speak with me and they were present. The people have Officer Tim McCormick and Officer Kyle Enriquez, who were both dispatched to the defendant's residence on the night in question due to a 911 call.
Okay.
Upon arriving there, the officers, one spoke with the defendant and one spoke with the victim. The victim is not present here today, but the officer could testify about his observations, what he saw that night regarding the incident. And additionally, as Sister Counsel alluded to, Officer Tim McCormick can testify as to what the defendant said. Specifically into the body-worn camera, the defendant admitted to hitting the victim, that he never hit her, that she woke him up by slapping him because he was cheating on her, and there were some other threats made, and that all of the violence came from the defendant onto the victim. At that point, the officers
Good enough for me.
arrested the defendant and continued to have talks with the complainant, but the officers could certainly testify about why they were called out there, the substance of the 911 call, what they observed upon arrival, the fact that the defendant was hiding in the apartment when they first entered the apartment with consent from the victim, and the observations that they did not see.
Okay. So as far as, since nobody has really briefed us, we don't have any real case law on anything here.
This isn't hard. If you can make a prima facie case without calling the defendant as a witness, you're past corpus delicti. This isn't rocket science. There's nothing hard about this. I'm going to get worked up again.
Question as to the corpus delicti, where is it? Who's it coming from?
It would be their
Oh my God. You're a judge that handles criminal matters. We have an admission. We have a victim who's hiding. We have the statement right there. We have police officers on the scene, and they're going to testify as to that. Do you know what the term means, Judge? Holy shit. She's unfamiliar with the term honky, World War II, and corpus delicti. You've got to be kidding me.
observations on the scene here.
that can make out the fact that a crime had occurred?
As far as the corpus delicti rule goes, I'll note that the court did rightfully bring that up. My understanding is that admissions are admissible as long as there is something else that corroborates that admission, which in this case we have the 911 call, the officer's observations upon arrival with the victim and the defendant present. The victim is packing up his belongings to leave the apartment, and he made statements to them that were consistent with the defendant's admissions.
Sure.
So I would not offer the victim's statements for proof of the truth of the matter asserted, given that the victim is not present, but they would corroborate the defendant's admissions.
They sure would.
Okay. So what do you want to say, if anything, to that?
I would say, Your Honor, and just let me get my here.
You're welcome.
This is not a case where my client had previously had the opportunity to cross-examine a complainant. It's still so with respect to the corpus delicti rule.
Yes, in fact, that was the worst of it, but I don't want to say it on my stream for obvious reasons. But yes, that's the worst of all the things that we've dealt with.
My understanding of it, and perhaps I'm wrong, I don't know for sure that I am, is that you do have to make out the elements of a crime before you use the defendant's statement. You have to have something to show that a crime was committed outside of the defendant's statements about it. So if there's no one knows about a crime and the only thing you have is the defendant saying that she did something that constitutes a crime, you can't use the statement. That's the way I understood the rule to be.
Yes, that there has to be some other independent evidence, Your Honor.
Yeah, that there was a crime.
Out of the court statement.
Right. So I don't know what the officers are going to testify to, but I don't know. I would just think that if the worst case the scenario, they have seen somebody with some injuries.
And even if they did, Your Honor, they still would not reach a level of beyond a reasonable doubt to where the court could find that those injuries came from my client. So, and I don't even think that is their testimony at all. No. So that's not even the testimony that they have.
Your Honor, I believe the reason behind this motion, and correct me if I'm wrong, is because I did make an offer to the defendant to plead under 769.48 as it is her first offense. So I would ask that if the court determines that this would be proper evidence or maybe wants to wait on your determination, that we allow the defendant the opportunity to take advantage of that offer or choose not to.
Well, we said no.
Okay.
That she does not wish to avail herself to plead guilty. She's not compelled to do so.
Just so she does understand, it's a plea without an adjudication of actual guilt. We hold it in abeyance. There is no record of a conviction unless she fails to do something that she might be ordered.
She's not going to take a plea when you just telegraphed that you're absolutely in the tank for this attorney. Are you kidding me? You just tipped your hand. Oh, I don't see any corpus delicti. Okay, well, that's because you don't know what the hell you're doing. But that's what you said, and now you're trying to work a deal. I don't know what to say about this. I guess I've already said it.
On a course of probation, then on violation, she could be taken off that status and the conviction could enter. But otherwise, it's not a direct adjudication of guilt because we don't enter it as such. And if she finishes everything, we just dismiss the case.
Well, she does not wish to avail herself of that, Your Honor.
Just so you understand it.
I don't blame her. The attorney comes up with this shim BS argument. The judge is buying it hook, line, and sinker. And then we're trying to discuss a settlement of the action. Why? I mean, it's crazy that she's buying it. But if I went up and threw some BS at a judge and they were biting on it, I would tell my client, don't plead guilty to this. She's going to dismiss it.
Yes.
And you wish to not take advantage of that.
Yes.
Okay. All right.
I also wanted to bring to the court's attention, I tried to speak with Sister Counsel about this, but I guess, I thought it was wholly inappropriate for her to address my client's grandmother, who potentially could be a witness. She is aware that my client, this is my client's grandmother, and she asked her personal information about my client's communication with there has not been any, but she asked if my client had been speaking to the complainant, etc. That's inappropriate. This is a witness that is with the defendant, and she does not have a right to speak to a potential defendant witness.
I have not received a witness list from defense counsel. So first and foremost, I did not know that she even would have a witness. Secondly, if defense counsel were present and on time for the 10 a.m. trial today, when I turned around and I asked the courtroom if counsel for the defendant was present, maybe the grandmother wouldn't have stood up and said, I'm here, I'm her grandmother, and then walked out with me. Where I did, in fact, ask her, do you know how she wants to proceed today? Do you know if she's had any conversations with the victim? And I believe that it's relevant. I don't believe it's inappropriate.
Well,
I'm sure
that's why we have witness lists from both sides. And if there's a discovery order that anyone requests, we sign it. And that allows discovery goes back and forth, even in misdemeanor cases. And I know that because it was my idea. And I took it to district judges and we pursued it and we changed the courtroom because I got tired of people saying, well, you can't have any discovery in district court cases. So that's how that rule came about. It's because of me. So I do know that you can have witness lists. And I'm not aware of a rule that says once you get the list, you can't talk to the other person's witness. Now, you might choose to tell your witness, hey, that's the prosecutor, that's the defense lawyer, don't have any discussion. But if I'm wrong, correct me. But I'm not aware that there's a rule that says the one or the other side can't be aware of what the witness is going to say, because that's the whole purpose of having a witness list. And so you know who it is. And so no one is hijacked or blindsided at trial because they don't have a clue who the person is or what they might say.
Well, Your Honor, just so there's no confusion, I did not know, and she did not indicate that she would be testifying.
I said there was no witness list, so you wouldn't have known.
I think that prosecutor, as well as the defense attorney, has the duty to just not have the appearance of an impropriety. First of all, clearly my client's grandmother is not her lawyer. So to say, because I didn't answer at 10 o'clock, that she thought she somehow might be her lawyer or someone she can get information from. If she's obtaining information knowing that my client has retained counsel, I think it's just a good general rule of thumb to not speak to anyone related.
Oops, that's cute. You think it's a good general rule of thumb. It's not, however, the law. So I don't care what your feelings are or what your general rule of thumb is. It's not the law. You can talk to anybody who voluntarily talks to you. What you can't do is talk to the defendant if you're a prosecutor. You can't talk to the party opponent. You can talk to their family members if they voluntarily talk to you all day long. I can't believe she's making this argument with a straight face. But after the last corpus delicti thing went so well, why not try anything?
To a defendant that you are prosecuting, especially if you are obtaining information that could be used against them. So I'm just saying, I tried to talk to her about it. She doesn't see the problem with it. I do, and I just wanted to bring that up.
Well, what would be the remedy that you would be requesting?
Well, I'm not, I don't know if my client is going to have to be a witness against herself and use words, and whatever was said to my client's grandmother is now brought in, and now my client's grandmother is brought in. I don't know what to expect in this proceeding if we proceed with a trial. So I just wanted to bring that up on the record, just to say.
Well, let me just say this too: is your client's grandmother? You can go back there and certainly talk to her and find out what she did tell the prosecutor. And if you thought that you needed some time to rebut it or deal with it, the court would certainly allow you the opportunity to do that. If you thought it was something that was even relevant that the prosecution was going to use, it doesn't sound like it was from what she just said. She found out, but I appreciate you advising me of that. Looks like the biggest issue, unless you have another one, is whether or not they have enough to make the corpus delicti a crime. And usually that would be something that I'd hold a little minor evidentiary hearing on. I guess I could start the trial, and you could make a motion at the end of the people's proof that they didn't meet the burden based upon whatever, like almost holding like a little evidentiary hearing.
Yeah. You could just have a trial. And then either the prosecutor meets the burden or not. I think that's where we need to go with this. Oh my God. Like, that was the inescapable conclusion from the get. I don't even understand this. Tell me, criminal defense attorney, tell me if I'm wrong. I look at this by analogy through the civil context. You can, in a civil case, you can't talk to someone who's represented. You can't talk to a party opponent with, if they have an attorney. No kidding. That's true in the criminal context as well. We have one other exception. You guys don't care, but there's a case in Illinois called Olympia Fields. The insurance companies used to do funky stuff, and they used to go and like strong arm all the medical providers, all the doctors. And they would call up and harass the hell out of them and be like, "You'll never get paid again," from the insurance mafia if you tell the truth. Okay, I'm exaggerating slightly, but there's that kind of funky stuff going on. So by case law in the state of Illinois, you can't talk to the client or you can't talk to their medical providers without a waiver. Anyone else is free game. Anyone else on the planet that is willing to talk to you, you can talk to. It's that simple.
Within the trial, that they didn't meet the burden of showing that there was the corpus delicti was met, and therefore it should be dismissed. That's the only way I know to proceed on that at this time, because I don't know what they're going to say.
Okay, retained expert. You can't talk to them either. You can depose them, but you can't talk to them outside of the context. Yes, a retained expert as well.
Quite frankly, if they can say enough to make me believe that there was a domestic violence prior to your client's admissions about it.
Well, I'm just saying, that it would have to be more than that, and based on what
I'm looking at this case, People versus Washington, says the purpose of the corpus delicti rule is to protect defendants from having a confession used against them where there is no independent evidence supporting the confession.
Correct. And if, I don't know.
Well, there is. I'm glad you've come around to that. But here we've got a 911 calling a victim. You see how that works?
This is when
That's a Michigan Supreme Court case.
Yeah. Or when if I don't know what her offer of proof would be to the independent evidence. Just having officers arrive at a scene and take a statement, or
obviously if they arrived after that, they didn't see the actual incident, so they can't be.
I guarantee you that is not the rule. The rule is not if the crime was not observed firsthand by a law enforcement officer, then it's a not guilty. That's not the rule. It never has been. I don't know why we're contemplating that as a possibility.
A witness to that. I don't know what else they saw that could lead one to conclude that a crime happened.
Well, I just think it's a stretch, Judge. I mean, even if I don't see anywhere where they say that they witnessed any bruises or anything of that nature. But then now we're into, well, where did the bruises come from? They don't know. They don't know when the bruise happened, or how it happened, or.
Well, we have to have it connected to a crime. So we can't just have a bruise that they saw. We have to have it connected to some kind of illegal activity. And that's what this rule says in People versus Ish. And that's a 250.
I mean, I hate to do this because it's just so boring and it's so obvious, but literally, you're telling me if the police are called to a domestic dispute, the defendant is a white male and she's got a bruise on her and he admits to it, that's getting pitched for corpus delicti? Are you effing kidding me? Never.
To Mishap 115. So
And
it
it
says the
shouldn't be.
rule bars the prosecution from using a defendant's confession in a criminal case unless it presents direct or circumstantial evidence independent of the confession that the specific injury or loss occurred and that some criminal agency was the source or cause of it. So I don't know if you can make that or not.
That's correct, Your Honor. People v. Washington also elaborates that the rule provides that a defendant's confession may not be admitted unless there is direct or circumstantial evidence independent of the confession establishing the occurrence of the specific injury and some criminal agency
Right.
is sufficient to show that the crime was committed by someone.
Is that the 514 Mish 583 that I mentioned earlier? People versus Washington.
I don't have the citation. I apologize, but it is People v. Washington, so it is the correct citation.
It's a 2024 case.
No.
So the only thing I can do is, hear the case and just decide if, based upon whatever they're saying, if there's a corpus delicti. I mean, you haven't waived the issue. Certainly.
I respect whatever the Honorable Court rules. I just don't think it's that.
Well, I don't have enough, I don't think, at this point to say before trial, yep, you're right. They can't make it unless we have a mini evidentiary hearing, which we might as well start the trial and call it an evidentiary hearing. And you can make your motion when she finishes her case and say, hey, we didn't hear anything that makes the corpus of the crime. And then I might say, yep, you're right.
Okay, that's effectively denying the motion because then you either make the case or you don't. If you do, then you got it, which is the right thing. She arrives at the right place by accident here. It's depressing.
Motion granted.
Respectfully, I don't wish to waste any more of the court's time. I would disagree with defense counsel in that I do believe we have enough evidence to go forward. However, in consulting with the officers and in addition to conversations with the victim that my predecessor in this court has had, as well as Detective Giovich, who was here at council table, the people will be choosing not to proceed today.
Okay. She want to dismiss without prejudice? That's all I can do unless you want to dismiss it with prejudice.
We are unable to proceed and choosing not to proceed and would not object to a defense motion to the city.
Yes, or
Oh, it's even more gutless.
With prejudice in that the court has heard some of what the evidence would.
Nobody was sworn. So I'm going to dismiss and grant your motion. It's going to be a dismissal Without prejudice, because I don't know that I have a basis to do it with prejudice. No, we haven't proceeded with not one witness. Had we put a witness on, I could have done it with prejudice, but we did.
Thank you.
So cancel the bond.